At the hearing, appreciate that panel members are unpaid volunteers giving their time as an act of public service. Their objective is to be fair, unbiased, and impartial, to determine, based on the evidence and testimony presented to them, what actually occurred, and then to determine whether the facts as they find them support a finding that the articles charged has been violated. Hearing panels cannot conclude that an article of the code has been violated unless that article is specifically cited in the complaint. If you believe, once at the hearing, that the right articles or all the allegations have not yet been cited, you may amend the complaint. Keep your presentation concise, factual, and to the point. Your task is to demonstrate what happened, or what should have happened but didn't, and how the facts support a violation of the articles charged in the complaint. Hearing panels base their decisions on the evidence and testimony presented during the hearing. If you have information relevant to the issues under consideration, be sure to bring it up during your presentation, or, even better, provide supporting documentation. Recognize that different people can witness the same event and have differing recollections about what they saw. The fact that a respondent or their witness recalls things differently doesn't mean they aren't telling the truth as they recall events. It is up to the hearing panel, in the findings of fact that will be part of their decision, to determine what actually happened. The hearing panel will pay careful attention to what you say and how you say it, and the implausible account doesn't become more believable through repetition or through volume. You are involved in an adversarial process that is, to some degree, unavoidably confrontational. Many violations of the Code of Ethics result from a misunderstanding or lack of awareness of ethical duties by otherwise well-meaning, responsible real estate professionals. An ethics complaint has potential to be viewed as an attack on a respondent's integrity and professionalism. For the enforcement process to function properly, it is imperative for all parties, witnesses, and panel members to maintain appropriate decorum. After the hearing, you will receive the hearing panel's decision in the mail. When you receive the hearing panel's decision, review it carefully. Findings of fact are the conclusions of impartial panel members based on their reasoned assessment of all of the evidence and testimony presented during the hearing. Findings of fact are not appealable. If you believe the hearing process was seriously flawed to the extent you were denied a full and fair hearing, there are appeal procedures that are available. The mere fact that a hearing panel found no violation is not a basis for appeal. Refer to the procedures used by AAR for detailed information on the basis and time limits for appealing decisions or requesting a rehearing. Rehearings are generally granted only when newly discovered evidence comes to light. A, which could not reasonably have been discovered and produced at the original hearing, and B, which might have had a bearing on the hearing panel's decision. Appeals brought by ethics respondents must be based on A perceived misapplication or misinterpretation of one or more articles of the Code of Ethics, B, a procedural deficiency or failure of due process, or C, the nature or gravity of the discipline proposed by the hearing panel. Appeals brought by ethics complainants are limited to procedural deficiencies or failures of due process that may have prevented a full and fair hearing. Monetary disputes with Realtor Rs RR. Arbitration facilities are provided by the Realtor R Association as a service to its members. Arbitration is not a disciplinary proceeding, nor does it award damages. There are certain disputes that realtors are obligated to arbitrate as a part of their membership duties. Be aware that not every situation may be arbitrated at a Realtor R association. Most disputes with clients or customers do not fall under the association's jurisdiction and must be handled through the civil courts. Also, disputes involving clients or customers require that the client or customer sign an agreement to arbitrate and to be bound by the arbitration, which means further legal action would most likely be precluded. Types of disputes that cannot be arbitrated at a Realtor R association include disputes involving damages that could result from a Realtor R's alleged error, misrepresentation, or other inappropriate action. This type of monetary claim would usually need to be handled through other processes, such as the courts or through informal settlement. A real estate attorney may need to be consulted. For more information on how to find a real estate attorney, you can refer to the Arizona Bar Association's website, www.aizbar.org. Types of disputes that may be arbitrated at a realtor association must be those in which the realtor promised to pay something, which means you and the realtor must have agreed on some type of a specific obligation that, if not met, the realtor would be obligated to pay something. For instance, if your buyer's agent agreed to purchase a lighting fixture for the house you are buying if the sellers took it with them, that would be a contractual matter and could be arbitrated. Whether the dispute is one that can be processed by the association is determined by the association's grievance committee.